I want to welcome you to the latest installment of McInnes Cooper's Labor and Employment virtual roundtable. My name is Darren Stratton. I work out of the St. John's, Newfoundland office, and I'm very pleased to be co-presenting today with Amos Stewart, who works out of our Moncton, New Brunswick office. We are but two of the members of our Atlantic-wide labor and employment practice group that have members in each of our 7 offices across Atlantic Canada. So I'm pleased that you could join us today. The topic today is employment contracts, and we've referred to both in the title, that in the invitation you received, and in the slides, to the potential for some of those employment contracts to be ticking time bombs. We're going to review some cases with you, mostly out of Ontario, where unfortunately that became a reality for some employers who were not able to rely on the provisions that they had included in the contracts that they were using. Hopefully by the end of our time together, we'll finish up within the hour, of course, but hopefully by the end of our session together, you'll have a better understanding of the issues that cause problems for enforcing those contracts that we'll be talking about, and you'll be aware of those issues so that you can take steps to avoid setting yourself up for a fall the next time that you enter into an employment contract. And hopefully you'll also be better prepared to look for and use opportunities to diffuse any of the potential issues with the contracts that you have with your current employees. The issue seems to be arising mostly with respect to termination clauses. They're the provisions that are being challenged by employees and their legal counsel in dismissal situations. The courts, and particularly the courts in Ontario, appear to be very willing to find that termination provisions are of no force or effect. So why is that a problem? Well, contracts in general are intended to provide some certainty of terms, and that's particularly important when we're dealing with longer term contractual relationships, and certainly employment relationships fall under that heading. Employment relationships can last years, if not decades, and it's quite foreseeable for an employee to be dealing with several supervisors or managers or even human resources personnel throughout the course of their careers. So it's important, in our view, that you address the rights and obligations that will arise upon the termination of the employment relationship, because some of those people, some of those individuals are going to change. Why is that important? Well, parties have an opportunity to negotiate a notice provision that displaces the application of this common law concept of reasonable notice. It's an opportunity for you to agree at the beginning of the employment relationship what the obligations, what the entitlements are going to be at the ultimate end of the relationship. Now, that's not to suggest that the parties and the employer in particular doesn't intend to be reasonable as to what will happen at that point of time. It's just that none of us have a crystal ball. None of us know with anything near certainty what the so-called Bardolph factors that are used to determine reasonable notice, what they're going to look like months, years, or decades down the road. You don't know how long the person will be working for you. You don't know what position they'll end up working in. You won't know their age, and you certainly won't be able to predict what that individual's ability would be to obtain alternate comparable employment in the environment and economic conditions that prevail at that point. So let's agree to it up front, and parties find a benefit in agreeing to it up front, because it avoids then an argument at the end of the relationship as to what the entitlement should be. So that's a great theory. The courts, though, they they have recognized in many situations for many years that employees have less bargaining power than employers do at the start of the relationship. They have recognized that employees are less likely to be familiar with the minimum employment standards to which they're entitled. And therefore, the courts are more readily and regularly demanding that the employment contract provisions in written contracts respect those minimum standards from legislation and otherwise be very clearly worded. So let's jump into some of the cases that we have available for you that talk about why some employers have tried to achieve that certainty, tried to displace the common law entitlement to reasonable notice, but have run afoul of some judicial scrutiny.
Okay, so now we're going to go on a bit of a drafting technicalities landmine journey, and Darren and I will be your tour guides on that journey. And we've got a bit of an itinerary up here for the first part, which shows the cases that we'll be talking about. So on this slide, you'll see the case names, which are the names of the employees who are suing and the years that the decisions came out. And as we go through them, you'll see it's becoming increasingly difficult to enforce termination provisions in employment agreements, as Darren was alluding to. So they are important cases indeed to be aware of. But we don't want you to go through the session thinking it's all doom and gloom, because it's not. So we promise that we will get to some of the ways that you can address the difficulties with drafting and enforcing termination provisions later in the presentation. But first, we need to understand where the issues are coming from. So in terms of the cases, these are all Ontario cases. So you may be wondering, well, why are we talking about them here in Atlantic Canada? Well, in our experience, judicial and legislative trends from Ontario do tend to make their way out here to the east. And you want to be ahead of the curve on this, because employment agreements that you're using now, you might only need to rely on them in the future. And so you want to make sure you've reduced your risk as much as possible with proper drafting. Also, in this remote work world that we find ourselves in, if you've got employees working in Ontario, these cases are going to be highly relevant to you, because usually the law of the jurisdiction where the employee works is going to apply. So we've got the 2020 Walksdale case that I'll be talking about. Then I'll hand it over to Darren to address the 2022 Rahman case, and back to me for the 2022 Henderson case. And finally, Darren will get into a really interesting recent decision, 2024, the Dufault case. So starting with the Walksdale case, which you may have heard of. We've been talking about it for a while now, because it is significant. And that's the 2020 case where the Ontario Court of Appeal decided that an otherwise enforceable without cause termination clause did not apply, because the for cause termination provision was problematic. So what does that mean? In Mr. Walksdale's employment agreement, there were two separate termination clauses. So one was dealing with termination with cause, and one was dealing with a termination without cause. Now, on its own, there was nothing wrong with the termination without cause provision, but the parties had agreed that in the litigation that the termination for cause provision was unenforceable because it violated the circumstances under which the employer could terminate without notice set out in the employment standards legislation. So even though Mr. Waxdale had been terminated without cause, meaning the employer wasn't trying to rely on the for cause termination provision. So even though it was a termination without cause, with a termination without cause provision that was properly drafted and compliant with the employment standards on its own, and even though the employment agreement also had wording that said that anything problematic in the agreement would be severed, i.e. removed from the agreement. So even though there was all of that, the Ontario Court of Appeals said, no, you can't separate with cause and without cause termination sections in their interpretation, even if they're physically separate in the agreement. You have to read them as a whole. And because there's a problem with one part, the whole thing falls away. So a pretty drastic result, meaning that the employer ended up being liable for reasonable notice of termination at common law, significantly more than the 2 weeks that Mr. Waxdale would have been entitled to had the termination without cause section been upheld by the court. So then we have the Rahman decision, which I will hand over to Darren.
Great, thanks. Yeah, so this decision, another fairly recent one, and all of the cases that we'll be talking about today are really within the last 4 years or so, which make them fairly recent in our view. This is another one out of Ontario from June of 2022, and this is an appellate level decision, like Waxdale was, and it probably takes Waxdale a little bit farther. The employee plaintiff in this case had been employed by the defendant company starting in February of 2016, and she was let go in April of 2020. And it appears from the facts, like a lot of the lawyers, some of the lawyers on this call will be aware, this seems to be something that was related to the pandemic that had resulted in a lot of layoffs and dismissals around the same time. She was a fairly well compensated employee, $185,000 per annum plus bonus eligibility. And when she was let go, she was 61 years old. And when this matter made it to the motions judge level, 16 months after the dismissal, she was still unemployed, looking for work. So a significant impact on her. So at the motions level, the trial judge, the motions judge, found that the termination provisions were just fine. Didn't see anything wrong with them at all. And part of the reasoning for that, that's pretty clear when you read that decision, is that the judge felt that Ms. Rahman was a reasonably sophisticated party. She was not unaware of these sorts of issues and entering into employment contracts. She had actually retained legal counsel to help her in getting some advice before she signed the final version of the contract. And as a matter of fact, through some back and forth negotiations, there had been some beneficial changes in her favor to the notice provision that actually went in the contract that provided a benefit beyond the Ontario Employment Standards Act minimums. So that was appealed by Ms. Rahman. And when we get to that level, the Court of Appeal in Ontario, there was an acknowledgement that the contract here contained a provision that said, look, none of the payments that we're going to give you are going to be anything less than what you're entitled to under the Employment Standards Act. You're going to receive the greater of what we have in this document or the Employment Standards Act. So the court acknowledged that there was a subjective intention to not contravene the legislation. But the problem, as in Waxdale, was that the contract included a provision that said the employee could be dismissed without notice or pay if she engaged in conduct that constituted just cause. Now, just cause is a concept a lot of you will be familiar with. It's a common law concept. But the court has repeatedly in Ontario said that's different than what the legislation says. Just cause is here, but in order to be disentitled to notice or pay under our legislation, you need to willfully misconduct yourself, which is a higher standard. It requires really some evidence that the employee was, quote, being bad on purpose, unquote. So because the contract in this case purported to allow the employer to terminate the employee without notice or pay that constituted mere just cause at this lower level, that was offside. And in concluding its judgment and finding that these clauses were void and unenforceable, the Ontario Court of Appeal said that we've repeatedly held that a termination provision in an employment contract will violate the Employment Standards Act, such as one where it says no notice if just cause, then all the termination provisions in that contract are invalid. So everything gets wiped out if you include something that crosses the line, doesn't respect the employment standards legislation minimum. So that saving provision, although acknowledged by the Court of Appeal, did not save this. The fact that the employee was sophisticated or had legal advice, that didn't save the situation either. And as a result, we have another contract that sort of blew up in the employer's face, and this older worker was therefore entitled to common law determined, reasonable notice determined in keeping with the common law approach. Anne.
So building further on the principles from the Walksdale case comes the Henderson case from 2022, where the court appeared to take it up just another step in finding a termination without cause provision unenforceable. So in this case, the Henderson case, it was the conflict of interest and confidentiality clauses in an employment agreement that were the problem. So essentially, both those clauses said that the employer could terminate without notice in the event of a breach of either. So it wasn't sort of strictly speaking, they weren't labeled termination clauses, right? So they didn't fall within a termination for cause provision labeled as such. But those clauses, the conflict of interest and confidentiality clauses, they dealt with termination matters, and they purported to provide the employer with the ability to terminate without notice in the event of breaches of those clauses. And so that was problematic because for the reasons that Darren was just speaking about in the Rahman case, you know, there's a higher standard under employment standards legislation for an employer being able to terminate without notice. And the court basically said, well, yeah, maybe in some cases if an employee breached the conflict of interest clause or the confidentiality clause, that might provide the employer with the ability to terminate without notice under the employment standards legislation, but maybe not in all cases. And so those things are contrary to the act and contrary to the minimum employment standards legislation, and therefore you've got this termination without cause provision that's perfectly fine on its own, just like it was in the Walksdale case. But employer, you can't rely on it. Because of the other problematic language elsewhere in the contract. And the court in that case made a couple of statements that I find troubling for employers. The first one was where an employment agreement is not consistent with the ESA, and the ESA refers to the Employment Standards Act. So where an employment agreement is not consistent with the ESA, it becomes invalid. So seems to be referring to the whole employment agreement. And then later on in the decision, the court says in its conclusion, clauses 18 and 10 of the employment contract, and those refer to the conflict of interest and confidentiality clauses. So clauses 18 and 10 of the employment contract were not in compliance with the ESA and therefore invalidated the employment contract. So it sounds like the whole contract sort of, falls away. And this is in line with a comment from the court in Walksdale that an employment agreement must be interpreted as a whole. So does that mean that anything in the employment contract that's contrary to employment standards makes the whole contract void? Obviously employment standards covers a variety of things, not just terminations. So for example, if the contract says that the employee gets less vacation time than they're entitled to under the employment standards legislation, is the termination without cause clause also unenforceable in that case? Now, we haven't seen anything like that happen yet, but I think that we need to be mindful that there could be risks if any part of the employment agreement is contrary to the Employment Standards Act. So another example, in Ontario, under employment standards legislation, non-competition agreements are now prohibited except in limited circumstances. So if you try to use a non-competition agreement where it isn't permitted, what impact might that have on the termination provision? In terms of the principle that employers should be encouraged to draft employment agreements that are compliant with the ESA, and that employment agreements should be interpreted with that in mind, and in favor of the employee where there's doubt. So this is concerning in terms of the broader impact that one sort of even a non-termination related matter could have on a termination provision. So we want to have that in mind when we're drafting and considering what to put in employment agreements. So I think we've come to Dufo next.
Right. Just before I jump in on part one of this case, I just want to confirm what Ann was talking about in terms of non-competition provisions. That was one of the questions that the participant fed to us before the session started, and I think it's significant. We've known for a long time that non-competition provisions in employment contracts were not likely to be enforceable outside of sale of business situations. But there's now an additional risk beyond just not being able to enforce it, as Ann said. So we're gonna keep an eye on the case law now that Ontario has prohibited those sorts of provisions, just to be further aware as to what the risks might be if it invalidates the entire contract. So I will do Dufault, or at least get a start on it, because I'll be returning to it later. This is an interesting case, as Anne said. We're dealing here with a youth engagement coordinator who was making $75,000 plus benefits. She was a relatively short service employee. She started on Halloween in 2021, and she was dismissed without cause towards the end of January of 2023. So just 15 months of service. And the operative contract, the written document that governed her employment at the time of her dismissal, had two clauses that dealt with termination. One, and you can see where this is going, because we're creating a little path for you here, but one of them said that the employer supposedly could terminate at any time and without notice or pay for cause, and then it went on to define what cause would be or might be. The other termination provision said that the employer could terminate at its sole discretion and without cause at any time by providing 2 weeks payment of the employee's base salary. So what's wrong with that? Well, according to the motions judge who heard this, neither of those clauses are enforceable. With respect to the for cause provision, as you probably anticipate, the court's going to have a problem with somebody who conflates this common law concept of reasonable notice with what the legislation requires, which is this higher standard of misconduct. And in this case, what the employer or its legal counsel tried to do was to say, well, this is what we mean by just cause. And unfortunately, it probably captured in some of the specifics that it listed some things that would not get up to that willful misconduct standard under the legislation. But worse than that, it said cause will include, but is not limited to. So by saying that, it included expansive language. It was open-ended, and there was no certainty for the employee as to what might disentitle her to notice. Of course, the other provision, the without cause provision, was also offside in the court's view, because it purported to be able to let somebody go with merely a certain amount of base salary. That's not what the legislation in Ontario says. It says that whatever your entitlement is, for whatever the duration is, it's for all regular wages, which could include commissions, and I don't think that was applicable in Dufault's case, but it would include things like vacation pay. So by trying to restrict it to base salary, they missed something that was an entitlement under the Ontario legislation. So that was offside, and both of those provisions were unenforceable as well. So I'll come back to this after we do a little detour with Anne first.
Okay, yes, this is a fun detour to take. Another fun area of drafting risk is fixed term agreements. And this also relates to employee rights on termination. I mean, that's essentially what this all relates to, because that's the you know, the big area of risk where the big dollar figures come in. And you know, there are various reasons to use fixed term agreements, and sometimes they might be appropriate, but we want to dispel you know, any notion that they reduce an employer's obligations or commitment to an employee because they're for a fixed period of time, rather than an indefinite, meaning an open-ended period of time. Using fixed term agreements actually do have greater risks involved. Under a fixed term contract, if the employer terminates the employee without just cause before the expiry date of the term, then the starting position is that the employee can sue for what they would have earned had they continued to work to the end of the term. Now, courts in Canada are somewhat divided on whether these damages, so the compensation for the remainder of the term, whether those amounts are subject to a duty on an employee to mitigate, i.e. reduce or lessen their damages by seeking other employment. So, there are mixed results on that, but, employers who are thinking of using fixed term agreements really need to be aware of the risks that they create, and they relate to several areas. So one of them is what I'll refer to as renewals. So where you have a series of fixed term agreements, that run back to back, or even a fixed term agreement that has an automatic renewal clause, then you might find that you've unintentionally created an indefinite employment relationship such that notice of termination is owing when you thought that it wouldn't be. So if you put a properly drafted indefinite term agreement in place in the beginning, then you avoid this. So renewals, be careful about renewals. Also, and we've talked about this. We saw this in the Dufo case, which Darren will get to, and I'll get to a case dealing with this as well. But liability for the remainder of the term, I mentioned that's the starting point. So unless there's a provision that permits early termination of the agreement, then you as the employer might just be liable for paying out the remainder of the term, which can be significant where you have a lengthy term. Another area is working past the termination end date. So, we put these fixed term agreements in place, and then you forget about them, and the employee might just keep working. The date goes by, and it's just not on people's radar. And so even if the employee works for a single day beyond the term end date, then a court might find that the employment is actually for an indefinite term, such that reasonable notice of termination at common law is owed in the case of a without cause termination. So if you do have a fixed term agreement, then you need to diarize that date and make sure that either you're ending the relationship or putting a new contract in place, or doing something other than just allowing the employee to continue working. Now, if you're in terms of, there can be arguments that arise over whether this is a fixed term or indefinite term agreement in the first place. It is, what's the nature of the term? So if your term or duration clause isn't properly drafted, and there's some ambiguity over what the intention was there, then you will end up with an indefinite term where notice of termination is owing, rather than just sort of an automatic end to the agreement. And that means that an improperly drafted fixed term contract will entitle the employee to that, reasonable notice of termination or contractual notice of termination, instead of allowing the employment relationship to simply end without notice, as the parties may have expected. So those are some things to keep in mind in terms of the risks of using fixed term contracts, and sort of a good example of the dangers. Real world example is the Dornan case, and that is a New Brunswick case. And this case shows us that fixed term contracts can mean big payouts. And this case falls into the liability for the remainder of the term category of risks for category of risk rather for fixed term agreements. And in this case, there was a CEO of a health authority in New Brunswick, and Dr. John Dornan, and Dr. Dornan was awarded in the end by an adjudicator, by an arbitrator, what could be the largest employment compensation ever awarded in New Brunswick history, and that was after he was abruptly fired, and the damages awarded were $2 million. So you know, employment law might not be an area of the law that people normally think of in terms of, you know, attach large dollar figures to, as you might in some sort of more commercial cases, but the damages can be very, very significant here. So essentially, you know, as a result of a death in a hospital, an emergency room here in New Brunswick, you know, this Dr. John Dornan, CEO of the Health Authority, was fired by the premier and the minister responsible, and the arbitrator was having none of it. There was an award of aggravated damages as well as the balance of the term. So it was, and just to mention, we had a question. I mentioned the arbitrator. You might be wondering why an arbitrator, not a court. We did have a question that was pre-submitted around arbitration versus litigation. In this case, because it was a public service employee, he was required to bring his wrongful dismissal complaint through this arbitration process rather than through the courts. So, you know, there are cases where it's sort of predetermined, you know, the avenue, you know, that arbitration is the required avenue in the, you know, in the labor context and unionized context, or in New Brunswick where you have this Public Service Labor Relations Act, and you know, the parties can certainly agree to this in their employment agreements as well, or agree on arbitration. But I think we'll talk about that more a little bit later at the end if we have time. In the Dornan case, there was a 5-year fixed term, and so the arbitrator there confirmed that without an enforceable termination clause or any other term to the contrary, that the employee is entitled to compensation for the balance of the contract. And the arbitrator found that the payment wasn't subject to an employee's normal duty to mitigate their damages. Although on a judicial review, so the province asked a court to look at the arbitrator's decision and judicially review it. the employer argued that under New Brunswick law, the employee's duty to mitigate does apply in the case of a fixed term employment contract, and the arbitrator was wrong to rely on contrary decisions from Ontario, which is what had happened. And the court in that case agreed that New Brunswick law does impose a duty to mitigate even in fixed term contracts, but that it made no difference in this case because there was the required evidence of a failure to, by Dr. Dornan to mitigate his losses. There was no evidence of that, or evidence of any actual earnings that he had after the termination. So it really didn't matter. But that's sort of one good thing for New Brunswick employers in any event, is that the duty to mitigate does apply in cases of a fixed term employment agreement. And so provinces and territories do deal differently with the duty to mitigate in cases of fixed term employment contracts, but just keep in mind that where the duty to mitigate does apply, the employer still has to prove that the employee failed to meet that duty, and that isn't always an easy task.
Okay, back to me. Thank you, Em. Back to me briefly to just pick up on the Dufault decision out of Ontario again, because there's another aspect to this case that was only hinted at in the slides that were the slide that was up on this before. I did mention to you that Ms. Dufault was employed in late 2021 and dismissed in early 2023, when she had 15 months of service. What I didn't tell you is that about 13 months into her employment, in middle to late November of 2022, the parties decided that they were going to enter into a fixed term employment contract. So this is different than the examples Anne gave of how people thinking that they have a fixed term contract can trip up and end up into a contract of indefinite duration. Here we have a relationship that started out with an indefinite duration, and then they deliberately decided to change this into a fixed term contract. So when Ms. Dufault was let go towards the end of January of 2023, that was only 2 months into this new fixed term arrangement, and a full 23 months before the term was supposed to end at the end of December of this year, 2024. So what's the significance? Well, we know that the notice provisions in the employment contract, as written at that time, were not going to be enforceable. So you would think, okay, now we're exposed to reasonable notice at common law. What's the big deal? We've got a 15-month employee. What's she going to be entitled to? 2 months, 3 months? Not a whole lot. But for the reasons Anne said, when you dismiss somebody with a fixed term employment contract, if you don't have a valid termination provision that lets you do something to the contrary, then the damage award for the employee is for the balance of that fixed term. So in Ms. Dufault's situation, and I should have advanced the slide, sorry, this is why I shouldn't be led around computers and have responsibility for it. The problem here is that she wasn't properly terminated under a provision. She was entitled to the balance of 23 months or 101 weeks of her base salary, 101 weeks of her benefits. No obligation to mitigate that damage claim. The only deduction was for the 2 weeks of pay and benefits that she had previously been paid under the employer's understanding of the contract. So that is Dufault. Back to Anne.
So we're sort of now getting into in the slides, the impact that unenforceable termination provisions, other terms can have. And we talked about a lot of this as we were sort of going. I mentioned that the Ontario decisions, they're Ontario decisions. They're not binding in Atlantic Canada, but they are persuasive. And courts in other provinces do pay attention to these things. So employers in all jurisdictions are wise to be aware of trends happening in Ontario. Like I mentioned, not just judicial trends, but trends in the legislation as well, which could impact your drafting of employment agreements. So in terms of reasonable notice, where a termination provision fails, and we've mentioned this multiple times, just putting aside fixed term agreements and liability for the balance of the term, we're looking at the starting point is always a presumption of reasonable notice of termination at common law. And so employers use employment agreements to try to limit an employee's right to that reasonable notice. And where those attempts to limit that right fail, there are cases, I guess, where more than 24 months of reasonable notice has been provided. So there's sort of a general 24-month cap on reasonable notice in Canada, but in New Brunswick, that's not the case. And in Ontario, we've certainly seen awards beyond that in exceptional circumstances. And so, we really are dealing with significant exposure to liability for reasonable notice, particularly where we're not just dealing with a salary, perhaps there's bonus long-term incentive payments. We saw a case a few years ago, Matthews and Ocean Nutrition, where the employee was entitled to $1 million as a result of a long-term incentive payment. So, depending on what elements of compensation are included in that reasonable notice payment, you really, employers can be on the hook for a significant amount. So that's really, what this is all about is entitlements on termination. So looking now the next slide in terms of termination provisions.
Yeah, before we move there, I think I just wanted to make a note, Anne, that you hit the nail on the head in terms of the longer the notice period is, the more money you're going to have to pay, and that money can be significant if we're talking about a highly paid employee who has the bonus or some sort of incentive program on top of what could be a significant salary as well. But the 24-month, you can take some comfort in that. I think one of the latest Ontario decisions, as you use the word exceptional, that there has to be something exceptional to get beyond the 24 months. Alberta, they talk about a rough upper limit. We maybe have a little bit better news in Newfoundland and Labrador, where the recent pronouncement, not at the appellate level, but in our trial division, did say that the 24-month notice is for long-standing senior employees in executive positions. So to get beyond 24 months, I think a plaintiff employee's lawyer is going to have to work to justify a longer notice period, but certainly it's out there. And even when we're talking about 2 years worth of notice, it can get expensive.
Absolutely. So I think in the interest of time, we've talked about the impact that unenforceable provisions could have on the broader contract. I talked about that in the context of the Henderson case, whether it could invalidate the entire contract. So maybe we can move on now to some of our tips in terms of avoiding or diffusing the ticking time bomb and things to remember.
Right. So this is the practical stuff, hopefully, that we've scared you enough to pay attention to it, but all is not doom and gloom. So I guess it comes under two headings, as this slide would suggest. First of all, review what you have, and secondly, then draft better. Get help if you need to draft better, by all means, but review what you have and do a better job in drafting. And remember, like those cases suggested, don't just focus on the without cause provisions in your documents, because people have been tripped up by the way that the notice provisions have been worded for cause. So that's Waxdale and Dufault. The plaintiff, sorry, the defendant in Henderson got tripped up because they referred to putting somebody out the door for cause, but that was in the confidentiality provision. So review everything in the contract to make sure there's nothing there that's going to trip you up. And that's for your active contracts. What I mean by that is the contracts that you have now that you're obliged to honor with your current employees. Look at your standard forms or your templates as well. And don't just include something like the confidentiality breach equals just cause equals you're out the door with nothing, merely for the fear factor, because that may not actually be helpful for you. There might be another way to go about that. In terms of drafting, despite what didn't get the employers over the line that we've talked about today, I'm still a fan of including a saving provision that says there's no intention here to escape the labor standards minimums. I'm a fan of severability and using separate clauses for the different types of notice situations that you can face. But overall, when you do seek to draft better, I think you need to have an overall view to make sure there's absolutely nothing in this document that even suggests that the statute is not going to be complied with.
So to sort of end things off before we look at questions, some things to remember. Remember to consider the applicable law in terms of what you're putting in your agreements, because the law varies by province. And generally, as I mentioned previously, the law of the province where the employee works likely applies. However, this can get more complicated where employees are traveling around and working in more than one place. And we don't have time to get into the specifics of that today, but it's just important in terms of, issue spotting. So just because, you're an employer who's located in, say, PEI, doesn't mean you can just make your contract subject to PEI law. You need to think about where your employees are located and what requirements apply, and ensuring that you're complying with the minimum applicable standards under the legislation. So in terms of the next tip, if you have to be mindful to think ahead to whether the termination clause or any other clause could at any point in the future violate employment standards legislation, because employee entitlements will increase with length of service. So it's not just relevant what the employee is entitled to at the time they start employment, but what they're entitled to as they go along. So if you start putting numbers in the agreement, like 2 weeks of notice, be careful, you know, because it might be okay. It might comply with what the employee is entitled to at the time, but it won't in the future necessarily. So if it drops below employment standards minimums at any time, if it could drop below employment standards minimums at any time, it won't be enforceable. And the last point, and it's a very important one, is that employers must take care changing the employment contracts of existing employees. So as Darren mentioned, you know, you should be regularly reviewing your agreements to keep up with changes in the law. But you can't just make employees sign new agreements just like that. You unilaterally changing a fundamental employment term or condition without giving the employee something new of value in exchange, that's known as consideration. So merely continuing their employment won't be enough. It has to be something additional of value that the employee wouldn't otherwise receive unless they signed the agreement. Or the other thing you can do is provide sufficient advance notice to ensure that your new contracts are enforceable. So that can be a little bit tricky to do, but just keep that in mind when you are looking at changing things for your current employees, and seek advice from your friendly neighborhood employment lawyer if you need. So I think we will take some questions now, unless you had anything to add to that, Darren.
Oh, I think that's a good summary. We are getting closely running out of time, but there's a couple questions that have come in. One's asked about you know, are fixed term contracts still something that could be used for summer students and things like that, and if there's any if there's still a benefit in trying to limit employment obligations. And my short answer to that is absolutely. It's helpful to let a summer student know that this is going to be your last day, and you don't have to remember at the end of June or the end of July or the middle of August to get that notice of termination to them. So that's why many people will still use fixed term contracts. The danger, though, a couple dangers. One, if you want to reserve the right to terminate the relationship before you get to the end, you've got to be paying attention to everything we've talked about today in terms of making sure that the termination notice is compliant with legislation. But there's the other things that that Ann mentioned, that if you've got a fixed term contract that says the student is done the Friday before Labor Day, don't have them back the next Tuesday, or you're going to run into some issues there.
So there's one other question I see in terms of no longer any benefits for limiting employment obligations. I mean, I think certainly it's very important for employers to continue to try to limit employment obligations. It's I agree, it's becoming increasingly difficult, but because of the financial ramifications, certainly it's possible to limit those obligations. You just have to be mindful of the drafting, so that you don't find yourself in a situation like the employers did in the cases that we reviewed. I hope I've understood that correctly. I don't know if you had anything to add there, Darren.
Oh, I think that sums it up. And remember, just because we're looking for certainty at the beginning of the relationship doesn't mean you can't contract for a fairly reasonable notice obligation or entitlement at the other end as well. We're just trying to achieve the uncertainty, avoid the uncertainty of having to figure that out and have a dispute at the end.
All right. So I think that brings us to the end then. Thank you everyone for joining us. We hope that you've found this to be helpful and at least helpful, if not interesting. And thanks again for joining us.